with a stroke of a pen, our legitimately earned past service has been sought to be wiped out. And the facts are like this. The whole process started with an advertisement, which your lordship will find at page 47. With a view to support, strengthen and improve the quality of elementary education in the state of Assam, in compliance with the RTE Act 2009, your lordship will kindly note this one. Online applications are invited in prescribed format from eligible candidates for the following positions under Assam Sarvika Abhiyan for teachers on contractual basis, candidates having requisite qualifications, etc. And if your lordship kindly turns the page, your lordship will find the qualifications.
Yes, page.
At the next page, your lordship will find the qualifications. These are absolutely at par with regular teachers. Now, if I may take your lordship to this, before taking your lordship through the further facts, if your lordship will kindly have the right to education, right of children to free and compulsory education, 2009 Act. There are just two statutory provisions that I would like to bring to your lordship's notice. The lordship will kindly turn to, there are some statutory mandates. Section 19. No school shall be established or recognized under the Section 18 unless it fulfills the norms and standards specified in the schedule. Now, Section 25 provides for the pupil-teacher ratio, which I had placed before your lordship in connection with the other cases. Now that ratio is provided in the schedule, which your lordship will find, if we are holding the same book, your lordship will find at page 21. In terms of this act, a set of rules have been framed. Your lordship will find that in the same book. If your lordship will kindly turn to Rule 20, schools owned and managed by them, in order to create a professional and permanent cadre of teachers. The whole idea was to create a permanent cadre of teachers. Now, sub-rule 3. The scales of pay and allowances, medical facilities, pension, gratuity, provident fund, and other prescribed benefits of the teachers shall be at par for similar qualification, work, and experience. Now, after this advertisement, appointments were made. We were appointed, and we have annexed the service book of one of the persons. This writ petition is filed by an association. That your lordship will find at page 51.
Yes.
If your lordship kindly turns to page 54, your lordship will find that for the first few months they were given a fixed pay. Thereafter, right in the middle of the page, your lordship will find pay band 2. So we were given, as per the mandate of the statute, we were given a regular scale. We continue to receive the increments. Now, if your lordship kindly turns the page to page 57, we were given the benefits of the pay revisions, refixation of the incumbent so-and-so, ROP rule 2017 and pay fixed at rupees 14,000 to 49,000, etc., grade pay, etc., etc. Now, if your lordship turns over to the next page, your lordship will find that in that payment 2 revised scale, we continue first. Funds for new recruitments under SSA would be approved only when all the state vacancies are filled up. Next sentence is very important. PAB also advised the state to do away with the dual cadre of teachers as all the teachers belong to the state. Now, if your lordship kindly turns to page 100, they were conscious of this position, and that is why this instruction is issued by the Commissioner and Secretary to the Mission Director, SSA. In inviting a reference to the above, I am directed to state that from the beginning, it was decided that the contractual LP UP teachers under SSA will get same benefit of regular teachers under the Directorate of Elementary Education Assam. It is to inform that it is decided that the contractual LP UP teachers under SSA will get same benefit as that of regular teachers under the Director of Elementary Education Assam with effect from so and so. Accordingly, you are requested to extend the 7th pay commission benefit to the contractual teachers. Here it may be pointed out that regarding allowing of grade pay, etc., to untrained graduate teachers as per 7th pay commission under the Directorate of Elementary Education Assam, who have been drawing grade pay of so and so as per ROP 2010, the matter was referred to Finance PRU department, and as per their advice, the matter has been placed before the anomaly committee and their decision recommendation is awaited, etc., etc. So basically, they accepted the fact that we are required to be treated at par with regular teachers. Now, there was in terms of this, at page 103, the mission director issued further instructions down the line, exactly same language. In inviting a reference to the above, it is to inform that it is decided that the contractual teachers, LP UP teachers under SSA will get same benefit as that of regular teacher under the Directorate of Elementary Education. So, now, if your lordship kindly turns to page 110, this is another notification, executive instruction issued. We are concerned with clause 4 at that notification. Entitlement of salary as revision of payrolls, so and so, and benefits of CPF, etc., will continue as per existing system. In fact, in the next one of the meetings that was held at page 112, it was the position taken by the government. Where is it? I'm sorry, my lord, page 125. (126) rather. This is another minus of the meeting under the Government of India. At page 126, line about 4th from top, your lordship will find. This is what was stated in the meeting. There is no dual cadre of teachers. Only financial support for additional teacher salary will be provided under the so and so thing. So they say, in fact, that there's no, and they're treating all through. We have been treated at par with the regular teacher. However, an interesting move was made, which your lordship will find at page 140. This is 10th of January 23. With reference to the subject cited above, I am directed to enclose herewith the model format of options for the contractual teachers and state pool teachers working under Samagra Shiksha Assam, presently working in the elementary schools of the state. The said category of the teachers are to voluntarily opt either for regularization of service with initial scale of pay benefits from the proposed date of joining, that will be fixed in due course, or to continue as contractual teachers with the existing financial benefits and service conditions. Absolute onerous condition imposed on us, and the format is at the next page, and it is in tune with what has been said in this. That either you continue as contractual teachers and enjoy the benefits that has accrued to you, or else you come into the regular cadre, but you will be at the initial stage of pay. This has been challenged in a series of writ petitions. In fact, those writ petitions are also listed before your lordship today for admission. I think affidavits have not been, pleadings are not complete. But be that as it may, in this, when we challenged it, this is the order that was passed. Page 1. With a view to support, strengthen and improve the quality of elementary education in the state of Assam and in pursuance of government approval by file number so-and-so, and in exercise of powers under Assam so-and-so rules 2024, online applications are hereby invited from willing and eligible candidates who are working as contractual and state pool contractual teachers under Samagra Shiksha Assam through the official website of so-and-so for filling up of 35,133 posts consisting of assistant teacher of lower primary and assistant teacher of upper primary and science graduate teacher in upper primary, etc. In the initial pay of pay band 2, rupees so. So now what they have essentially done is what was prevented by way of an interim order in the earlier round of litigation. Now they are bringing in an advertisement saying exactly the same thing. That if you want to come into the regular cadre, you come under this advertisement, face the selection, but you will be placed at the initial pay of this pay band 2. In my respectful submission, Malad, this has multiple ramifications, but two basic things, Malad. This is an absolutely out and out colorable exercise of power. What was prevented in the earlier round of litigations which are still pending adjudication? That is exactly what they are seeking to do by way of this advertisement, which in terms of the settled principle, there is a division bench judgment of this court saying that when the court is in session of a matter, you cannot administratively take a bypass and do the same thing. That is number one. Secondly, my lord, what happens to our past service? We have faced the selection. It is the statutory mandate which says that there should be a permanent cadre. You have all along understood it to mean that we are at par with regular teachers. The moment you do this, you are putting the clock back and bringing us to the initial stage of the pay, which means you are treating us as fresh appointees. Would that be legally permissible? That is the question before your lordship in this case. And that judgment may have please follow. Although it is in a slightly different context, but the principle would certainly apply. This is 2014 4 GLR, page 3. So lordship will come to page 15, my lord, the ratio that was laid down, paragraph 15. When the court is in session of a matter, an administrative authority cannot start a parallel proceeding on the very same subject matter at its own ipse and record a finding on the issues. If such an action is taken, the same will amount to directly interfering with the dispensation of justice by the courts of law. And here is a situation where when you attempted at doing the same thing by way of inviting options, there was an interim protection given. Your lordship is examining those matters. Where is the question of doing the same thing through an advertisement all over again? In my respectful submission, this is out and out a colorable exercise. Your lordship will examine the matter. I'm sure they would like to contest it by filing their affidavits. But in the meantime, let this advertisement be stayed. Otherwise, what happens is we have been appointed from 2012 to 2014. 2017. There are some subsequent appointees also, assuming a person appointed in 21-22. For him, he has nothing much to lose. He will apply, even if it would be a matter of maybe losing one increment. But your lordship will kindly see our plight. We have been enjoying from 2014 onwards. It would also amount to treating unequals as equals. So, looked at from all perspectives, this is perhaps a case where your lordship will cause an intervention. State this advertisement, hear the matter as expeditiously as possible. I can understand it pertains to a recruitment of large number of people.
That's service book.
The service book, man. That your lordship will find at page 51.
Under which pay band was this?
Same pay band 2.
Pay band 2.
Your lordship will kindly first turn to page 54. Your lordship will find that initially we were given fixed pay.
Yes.
Just after that, your lordship will find pay band 2. This was the pre-revised scale, 5,200 to 20,200. Now, under that pre-revised scale, if your lordship looks down in the same page, your lordship will find that we were given the increments. Now, if your lordship kindly turns to page 56. Pay band 2, This is pre-revised 5,200 to 20,200. Just after that, your lordship will find pay band 2. This is the revised scale, 14,000 to 49,000. Now, if your lordship kindly turns the page to 57, your lordship will find that refixation has been done. Allowed to draw the scale of pay of so and so 14,000 to 60,500, grade pay so and so. And next page, your lordship will find that under this revised scale also, we have received several increments. Right from 2019 onwards. Now, this entire thing, three things will happen. We will lose our seniority because they are treating it as a fresh appointment. We will lose all the benefits of pay that we have earned because they are expressly saying in the advertisement that it will be at the initial stage. If your lordship looks at the impune advertisement once again, they have made it very clear in the initial pay of pay band 2. So it amounts to wiping out the entire past service. Therefore,
Yes.
Lordship, I'll not open all my cards today here. Lot of subsequent development have taken place. So when we have given them the option to whether they would like to continue as a contractual teacher or straightway they want to opt for regularization. That decision or that option was given to them by the department without knowing what is the actual law in place. No contractual appointee can be regularized straightway. The Oma Devi's judgment is still applicable. The Constitution Bench judgment of the Supreme Court says contractual teachers cannot be regularized straightway. So the government, after second thought, after a lot of deliberations, that option, that decision which was given to them, that they can opt for regularization by going to their basic pay scale. So that option, that whole exercise was abandoned by the government.
Have you withdrawn the option?
Yes, we have
Where's the
withdrawn.
withdrawal?
I'll give the lordship. In our affidavits, we will place it. Thereafter, we have a rules in place. So we have amended the rules. We have to first challenge the rules. They have annexed it. Page 153.
One?
153.
Yes.
11 July 2024. In exercise of the power conferred by the provisions of Article 309 of the Constitution of India, the Governor of Assam is hereby pleased to make the following rules regarding the recruitment and conditions of service of the experienced teaching employees in the elementary level and to further amend the Assam Elementary Education Provincialization Rules 1977, herein after referred to as the principle. So we are concerned about amendment of Rule 3. In the principal rules in Rule 3, after Sub-Rule 9, the following new Sub-Rule 10 has been inserted. The government may, in special circumstances, recruit experienced teachers by Special Recruitment Drive to recruit regular teachers in appropriate cadre from the existing contractual teachers and state pool teachers working under Samagra Shiksha Abhiyan continuously at least for 5 years, whose post shall be personnel to the concerned teacher and shall cease with the superannuation of such teacher, and their salaries and other emoluments shall be fixed as per ROP and with such other conditions as may be fixed and notified by government from time to time. So this amendment has been brought because straightway, if we have converted the contractual teachers to regular teachers, the law would not have permitted it. This is a very recent development. And furthermore, we have created 35,133 posts on 1st of August this month. Against this, we have advertised. Those who want to opt for this, they can always go. We have total about 35,133 persons who are actually eligible, having fulfilled the conditions of 5 years of service. If they are interested, they can apply. If they do not have the interest, they cannot apply. Till now, today is the last date, we have received applications of 22, about 23,000. So, if Lordship is pleased to stay this advertisement, it will go against their interest, not our interest. Let them participate. What is their core issue? The core issue is that whether they should get the pay scale from payment 2 or the existing pay scale which they are enjoying. That is one. But under the new scheme, they will get all other benefits, including pensionary benefits.
Under this amended rules.
Under the amended rules, they will get everything. Earlier, they will not have got it. If they are still continue with the contractual, they will not get pensionary benefits or lot of other benefits, which the government employees, regular government employees get. And on top of that, Lordship, I have a fundamental objection. If Lordship is pleased to look at their, because this is a case filed by the association. Photo from Prathamik that Untirno Tikho Kamas. If Lordship is pleased to come to the validity page 46. In the present form, it is not maintainable. In the certificate of registration of the Societies Act, it is valid up to 25th of June 2023. Just above this scanner mark, barcode. So they can individually come, but as an association, they are not eligible to apply, file this application.
We have our extension.
Do you have your extension?
They let them file to an affidavit. Because they have filed it, they should have filed the upgraded or the revised one also. So as on date, on record, they are not eligible to file this petition as an association. So today, Lordship may not be pleased to pass any interim order on it.
See, the notification, the advertisement.
Yes,
It says initial pay.
absolutely. We have the right, as an employer, we have every right to put the service condition.
Then what about the other increments and the other things that you are receiving now? That's gone.
There, what? Lordship will kindly see the original advertisement. Original advertisement when they have applied in 2012.
That is a different thing.
That is a different thing. That is absolutely the exact thing.
At that point of time,
At that point of time, government is under no compulsion to regularize them.
correct.
Absolutely no. They, with their wide open eyes, applied in 2012, got their job on the pay scale or whatever fixed pay, they got it. Government, because of some leniency, decided to give pay scale. The original advertisement did not consisted of the pay scale.
No. It's not because of leniency. It's because of the RT rules.
It has nothing to do with RT rules. Now, what is an RT rule? That is a central legislation. That is a central legislation. What about this PAB advisories? These are central government authorities. Now the state government is taking what now the government of Assam is now doing. Everything will be paid by the Assam government's treasury. There will be no support from the central government. When we had this pool under the Service Shiksha Abhijan Lordship, a substantial amount comes from the central government to pay them. Now, Assam government from its own pocket is going to pay them all the benefits, including pensionary benefits. So the situation is totally different, and they still can continue. Ultimately, whatever Lordship said, that will be at the final stage. But at this stage, that cannot be the core issue. Now, if the order is stayed, the government of Assam is now doing, everything will be paid by the Assam government's treasury. There will be no support from the central government. When we had this pool under the Service Shiksha Abhijan Lordship, a substantial amount comes from the central government to pay them. Now, Assam government from its own pocket is going to pay them all the benefits, including pensionary benefits. So the situation is totally different, and they still can continue. Ultimately, whatever Lordship decides, that will be at the final stage. But at this stage, that cannot be the core issue. Now, if the order is stayed, the advertisement is stayed, the whole thing will get delayed. Because what we are doing now, we are recruiting these persons under the new scope of things which comes with the communication of 1st August 2024, by which we have created 35,133 posts under the state. So those who have applied, the 23,000 applicants, their interest will be affected. Not everybody is qualified to apply under this advertisement, because those who have completed 5 years of service, because in 2022, 2021, we have further recruitment of contractual teachers under SSA. And there is a long-term demand from them that they want regulation. But regulation we cannot do. Government in a hurried manner did that. But when they have realized that it is a direct violation of the Supreme Court judgment, as well as various judgments of this honorable court.
Leonard AG, I think you should have a relook into your advertisement.
I leave it to your lordship. I'll be more than happy if lordship. I'll be more than happy. The government wants to help them.
Now that we understand,
We want to help them. If they are not ready to accept the help,
But the conditions of
the condition government can always. The conditions is very clear, lordship. If they still want to, because when we see why a contractual employee cannot be regularized, the law is well settled and well discussed. That when I have seen an advertisement, this is a contractual appointment. Lot of persons do not apply there also. They cannot foresee that in future their post will be regularized, because all the contract agreements, if I place them, there is a period of 12 months or a particular period, contract period. And in all the recitals of those contracts, lordship, it is very clear that they will not claim regularization. So with their eyes wide open, they have accepted all the service conditions. So when we try to regularize them, we are doing injustice to those persons who thought that it's a contractual appointment, so we are not applying. So we have to think it, because lordship will have to think the persons who are before this honorable court, as well as the persons who are not before this honorable court, when there is a policy decision of the government. So we have to consider everything. So they entered service knowing fully well that they have a contractual appointment with fixed pay. They cannot have legitimate demand. Government on its own wisdom is trying to help them now. That you will be regularized. But government also have, because now once we have this 35,133 posts created by the state government, we have to consider it from the state pool budget.
One thing you should keep in mind is when they initially entered the service, whether on contractual or whatever, they entered through a proper selection.
Absolutely, but still the law is very clear.
Maybe on contractual, but they entered through a proper
Absolutely,
selection.
that is why now what is the thing? Those who now we have calculated what is the total number of posts who will be eligible to get this benefit under the new amendment rules, about 35,000. So no new person can apply here. Their selection is guaranteed. There will be not 35,134 persons. There will be maximum is 35,133. Exactly. So they are assured of selection. If suppose we give an advertisement of 35,133 post advertisement, there will be more than 5 lakhs applicants. So they do not have to contest anything on merit. They are already into that place. So now what we are trying to do is that we are trying to change the condition of service. But we have also taken a decision earlier that they will not be removed from service till they attain the age of 60 years. Their contractual employment is also assured. So a lot of benefits are here, but certain benefits, even if we wish, until and unless Uma Devi's case is reversed, number one, and until and unless there is an amendment in the rules that one more additional mode of appointment is contractual employees can be regularized. That can be another, because law is again very settled that regularization cannot be a mode of appointment. So when they come here to the state government's pool, so they have to be there as a state government employee when they were working under servicing services, that is under a scheme. Okay. So there are two different angles, lordship. We have given our thought on this whole scheme. So lordship may be pleased to issue notice, let them participate, whoever is, And that final decision, whatever Lordship takes after full hearing, that can be given effect to. Or that the advertisement cannot be stayed at this stage, or may not be stayed. Let the process continue, because once they are appointed under the state pool, the issue which will remain is that whether they will get the present pay scale or the pay scale at the rate of payment 2. That is the only issue which is left to be decided by this honorable court. That can be done at a later stage also. Today that is not possible. But if the advertisement is state lordship, the whole thing will get delayed. I am open to that also. That I should not delay, but it will be detrimental to their interest.
Yes.
I'll give a quick reply to each of the points. Firstly, one of the submissions that was made was that permanent cadre is under central legislation. Your Lordship will kindly have the Assam Right of Children to Free and Compulsory Education Rules 2011.
Who is that?
In the education manual. I think we are holding the same book, so your Lordship will find it at page 241. An absolutely identical provision in perimeter is incorporated there in the central rules. It is Rule 20. Your Lordship will kindly see Rule 18 of the Assam rules at page 265.
Yes.
Page 265, Rule 18.
Yes.
The government, autonomous council or local authority, as the case may be, shall notify terms and conditions of service and salary and allowances of teachers in order to create a professional and permanent cadre of teachers. And similar benefits, sub-rule 3. Same language like in the central rules. That is number one. Number two, your Lordship will come back. The other submission that was made was based on page 153, the amendment to the rules. Your Lordship will kindly come to page 153. Where does it provide that it will be at the initial stage of the pay? It rather says that will be fixed as per ROP, which gives a clear indication that the pay protection will be there. It is rather the advertisement is in violation of these amended rules. It is for this reason that we have not, and we have made a specific amendment at paragraph 54, that this advertisement is in violation of the amendment. When your Lordship compares this amendment with the advertisement, your Lordship will notice the stark contrast. It nowhere says that it will be initial paid. It is an administrative decision. It is not in terms of the rules. And thirdly, my lord, Umadevi relates to all those backdoor entries.
That's why I was saying.
Exactly. So that analogy will not come. Because your Lordship will kindly take note of the peculiar facts in this case. Firstly, we face a selection. Although they have termed it contractual teachers, the statute says that it will be a permanent cadre, which is indicative of the fact that we will be treated as regular employees. They have understood it similarly by virtue of the document which I placed, my lord, page 100. If your Lordship kindly comes back to page 100. That is how they have understood it all along. This is by none less than the highest officer of the Education Department, Commissioner and Secretary, and it is an instruction being issued to the Mission Director SSA. And your Lordship will kindly peruse the first paragraph. In inviting a reference to the above, I am directed to state that from the beginning, it was decided that the contractual LPUP teachers under SSA will get same benefit of regular teachers under the Director of Elementary Education Assam. It is to inform that it is decided that the contractual so-and-so under so-and-so will get the same benefit as that of regular teachers under the Director of Elementary Education. Because the statute provides so. That cannot be taken away by way of an executive decision in the manner in which it is sought to be done. These are benefits, statutory benefits which have accrued to us. And it is for this reason, even when they invited options, Your lordships intervened in the interim, having examined all these things. And same thing they are now trying to do it through an advertisement.
Where is the withdrawal of the option for
Lordship, that decision it has been communicated to me. That is why this amendment and everything has come up. If we withdraw it, Lordship, suppose we withdraw it, then all the earlier decisions will become infructuous. And at that point of time, there was no additional post. The post which we have advertisement was created only on 1st of hardly 11 days ago. So when they were earlier tried to be brought into the regular stream, the existing vacant posts were there. Now what we have done, this is a totally different exercise, number one. And regarding this permanent ward in the Central Act of 2009 as well as the State Act, that permanent cadre is already there. Even before 2012, these contractual teachers, why they were recruited? These were recruited to fulfill the norms of people-teachers ratio. When there is shortfall, these contractual teachers are taken up. Then they were given the job in the school so that the people-teachers ratio is maintained. And when the state regular teachers come up, gradually the contractual teachers will reduce. So the Central Act as well as the State Act has nothing to do with the advertisement conditions, whether it is a permanent employment or regular employment or contractual employment. So that word will not change the color of the advertisement. The advertisement which was issued in 2012, they should have challenged that if they wanted the permanent, because permanent cadre is already there. These are stopgap arrangements. These are fillers. So that is number one. Regarding the Uma Devi's case and subsequent, even in Jagjit Singh's case in 2011-12, the Honorable Supreme Court said they cannot be regularized, therefore give them the minimum pay scale. That is precisely the reason why the state government has adopted this policy, not only in case of the contractual teachers in SSA, but also in case of master role and work charge employees in other departments of the state.
okay?
And number three, if the advertisement is stayed today, Lordship, what will happen now? These 22,000 who have applied, or there may be more also, they will join service as a regular teacher. This hearing will take place about 6 months to 1 year later. Yes, the normal procedure in the court. If tomorrow one teacher who has joined as a regular teacher died in harness, his or her family will get all the benefits of compassionate appointment. Those, if Lordship is pleased to stay, the whole thing will go against them. Suppose in 1 woman's time, one teacher dies after joining. The whole family will get the benefit if they are a government regular. If they are contractual employees,
You file your affidavit.
I will file it.
Within 2 weeks.
Lordship will give us 2 weeks, no problem.
Then we can dispose it
Yes.
already.
So only notice will be issued today.
I'm passing in it. I'm not, yes.
And then the 4 weeks time, regular time may be given to us.
But Mr. Chaudhary,
I will not file it 2 weeks, later 4 weeks time may be given.
you want 4 weeks.
Yes.
I, Chaudhary, Leonard Senior Counsel, assisted by Mr.
SP Sharma.
S.B. Sharma, Leonard Counsel for the petition. Issue notice. Mr. N.G. Katania, Leonard Standing Counsel, Elementary Education Officer, Education Department. Oh, should I report your name?
Yes, yes.
Mr. D. Saikel, Advocate General Assam. Assisted by Mr. N.G. Katania, Leonard Standing Counsel, Elementary Education Department. Appears for the respondents 1 and 2. And SSA? Who was SSA?
My only pleasure, let us process the applications. We will not issue the appointment orders. That order may be passed. That will create further third-party rights. 22,000 applications, that will take a lot of time for assessment. It will, if they want the NMAS this unlocked stay also, no problem, Lordship. I have no objection.
SSA, who's happening?
B government. It's a B government.
B. Goel, Mr. B. Goel, Standing Counsel, SSA. Appears for the respondents 3. Notice and respondents are complete. However, extra copies you have on sales. Respondents are not to file a counter affidavit. Release the matter after 2 weeks or 4 weeks?
4 weeks.
After 4 weeks. In the interim, the advertisement dated 6 August 2024, issued by the Director, Elementary Education Assam. Inviting online applications from contractual and state pool contractual teachers under SSA for filling up 35,133 post of assistant teacher of lower primary, assistant teacher of upper primary, and science graduate teacher in upper primary shall remain suspended till the next week.